The Canadian Constitution is the supreme law in Canada. A constitution is a list of rules which governs the action of any organization. A student council will have a constitution which stipulates the accepted rules of practice. Nations have more complex constitutions, but their purpose is the same. A good constitution is easily understood by those to whom it applies. It is not ignored by those who are elected to power, and it can be changed easily, but not too easily. A country must be able to update their constitution to meet modern needs. An amending formula must be written into the Constitution. The amendments that are made must meet the requirements of most of the people. A nation's constitution is often complex and lengthy. They can, however, be very simple. Great Britain has an unwritten constitution based on common practice. The Canadian Constitution is both written and unwritten. One of the most important early Canadian constitutional documents was the British North America Act of 1867. By this act, the colonies of Canada, Ontario and Quebec, were reunited with the colonies of Nova Scotia and New Brunswick. It is the foundation of Canada. The British North America Act described the Union and set out the rules by which it was to be governed. The Fathers of Confederation who wrote this document were influenced by many factors, including the American Civil War of 1860 to 1865. They had a choice between strong provinces and strong federal union. They decided that a strong federal union was best for Canada. It is important to remember that Canada is a federal union. This type of union provides for a sharing of power between a central government and the separate governments of the individual provinces. A strong federal union places more power in the hands of the central government than it grants to the provinces. Two sections of the British North America Act listed the powers of the central government and the provinces. Section 91 listed the powers of the central or the federal government. These included things such as national defense, fisheries, currency, the postal system, and other national issues. Section 92 listed the powers of the provinces. The province has power over hospitals, public land, justice, education, and municipal institutions. All powers not granted to the provinces were given to the central government. This covered all matters concerning the peace, order, and good government of Canada. Since the very beginning, the provinces have struggled to take power away from the central government. This struggle continues today and is often the source of considerable friction between the two levels of government. Amending Canada's Constitution was very difficult. The British North America Act was a British law enacted by the British government. This meant that it could only be changed by the British Parliament. This was a very complex process, and it resulted in few significant amendments. Much of Canada's constitution was unwritten and consisted of British parliamentary traditions and practices. These were called conventions. Things changed with the Statute of Westminster in 1931. By this British law, Canada became a self-governing dominion. This meant that laws passed by the Canadian government could not be overturned by Britain. It also meant that British law no longer applied in Canada. Even though Canada was a sovereign and independent nation, it still had a foreign constitution. The growth of nationalism in Quebec was a catalyst to change this situation. The Liberal government of Pierre Trudeau finally undertook this difficult task and achieved patriation in 1982. To patriate means to bring home. The process required that the British government revoke the BNA Act of 1867. It further required that Canada enact its own written constitution. The Trudeau government was faced with problems. The federal-provincial agreement in Canada meant that the provinces had to agree with the repatriation of the Constitution. A formula had to be brought forward in such a way that the Constitution could be amended. And then there was the Charter of Rights and Freedoms. The provinces and the central government had difficulty finding any common ground in order to achieve the goal of a patriotic constitution. The political leaders of each province wanted to ensure that the new constitutional arrangement was advantageous to them. Frustrated by the squabbling between the provinces, Mr. Trudeau asked the Supreme Court of Canada if he could patriate the Constitution without their agreement. The ruling indicated that it was legal, but not conventional. Now to deal with the Charter of Rights and Freedoms. Mr. Trudeau wanted an entrenched Charter of Rights and Freedoms. Entrenched meant that it was to be an integral part of the Constitution. The provinces objected to this as they feared a loss of power as a result of judicial interpretations of an entrenched charter. Agreement was finally reached between the central government and 9 of the 10 provinces in November of 1981. Only Quebec refused to be a party to this agreement. On April 17, 1982, royal assent was given by the Queen to the Canada Act. An entrenched charter, which could not be changed other than by constitutional amendment, was included in the Constitution. Provinces were allowed the notwithstanding clause, which provided exemption from some of the provisions of the Charter. To amend the Constitution, 7 of the 10 provinces of Canada that represent at least 50% of the population and the Canadian Parliament must agree. Changes to the monarchy, composition of the Supreme Court of Canada, or language law requires all 10 provinces and the federal government to agree. In 1987, representatives from all of the provinces and from the federal government met in Meech Lake in order to try and bring Quebec into the Constitution. They offered a distinct society status, which was to be confirmed for Quebec. The provinces were to be given the right to nominate judges for the Supreme Court. The accord was not ratified by all 10 provinces and therefore failed. The Charlottetown Accord of 1992 was a major constitutional amendment package. It included a distinct society status for Quebec, Aboriginal self-government, and reform of the Senate. It failed to pass a national referendum in October of 1992. In summary, the constitutional debate in Canada remains unresolved. Quebec is still not a part of the Canadian Constitution. Aboriginal Canadians feel that their right to self-government has not been achieved. For many Canadians, Senate reform is way overdue. Under the Charter of Rights and Freedoms, we have many guarantees. One is the freedom of speech. The freedom of speech is subject to a reasonable limit. This is the common sense clause, which allows governments to limit freedoms if it is reasonable. Courts must decide what is reasonable. Canada has some fundamental freedoms: the freedom of conscience and religion, the freedom of belief and expression, freedom of association, and freedom of peaceful assembly. The provinces feared that these were too broad, and as a result they were limited by the notwithstanding clause of the Charter. As Canadians, we have democratic rights. We have the right to vote, the right to run for elected office. Elections are to be called once every 5 years. Parliament and legislatures must sit once every 12 months. We have mobility rights, the right to leave and return to Canada, the right to move anywhere in Canada to live and to work. Reasonable residency is required for access to social services. Provinces cannot limit the right of non-residents to own property. We have certain legal rights, the right to life, liberty, and security of person. This limits the power of the government to detain or deny people basic liberty, except in accordance with principles of fundamental justice. Legal rights can be limited by the notwithstanding clause. Arbitrary arrest is not allowed. Police cannot unreasonably search any person. You must be informed of the reason for your arrest. You must be informed of your right to retain a lawyer. You have the legal right to be equal regardless of race, nationality or ethnic origin, color, religion, sex, age, mental or physical disability. Affirmative action programs do allow special treatment for those who are disadvantaged. These equality rights may be limited by the notwithstanding provisions of the Constitution. Canada is officially a bilingual country. Minority language rights apply only to Canadian citizens and not to new immigrants. English or French-speaking minorities can have their children educated in their own language. The provinces need only provide minority language schools when there are sufficient numbers to justify the cost. The Charter of Rights and Freedoms is guaranteed under the law. An individual may apply to the courts to stop any activity they believe to be discriminatory. Courts may challenge laws that take away basic individual rights and freedoms. The Charter takes power away from Parliament and the provincial legislatures and gives it to the courts. The notwithstanding clause of the Charter of Rights and Freedoms allows governments to pass laws which may interfere with fundamental freedoms, legal rights, and equality rights. There is an ongoing conversation about the Charter of Rights and Freedoms. Some people believe that Parliament and the provincial legislatures have lost too much power to the judges. Parliament and the provincial legislatures can overrule the courts by means of constitutional amendments. Most people believe that the courts have been effective and fair in interpreting the Charter.